Ready? Start. We find that no order of appointment in favor of petitioner actually was issued by the institution on the basis of advertisement dated 19/6/2003. From the recommendation of the selection committee, it cannot be denied that petitioner's name was at serial number 3 in the absence of issuance of appointment order as contemplated under clause 3 and 4 of the government order referred to above. No liability for payment of salary from state fund could be created. The petitioner has not been able to demonstrate that any payment whatsoever on honorarium basis was released to him. It is quite obvious that as the name of the petitioner appeared at serial number 3, issuance of an order of appointment in favor of the petitioner was otherwise not possible, ignoring the claim of others who were higher in rank. We have gone through the pleadings of the writ petition and its annexures, and we find that the petitioner has not disputed his appointment made against the self-financed evening course for evening classes. The only statement made in para 24 of the writ petition stating therein that the director illegally relied on the statement of the principle that the petitioner has been appointed under evening classes and that the said finding is not based on any evidence is not sufficient. Petitioner has neither before this court nor in his representation stated that he has not applied for appointment under the self-financed evening course or that he has not worked or received salary for it. The further explanation of the petitioner that management deposited his salary from its own funds without his consent is also not acceptable. In such view of the matter, we do not find any error in the finding contained in the order passed by the director that the petitioner was actually appointed as a teacher in self-financed evening course for which responsibility of making payment of salary fell exclusively upon the committee of management. The brief facts in the petition are that the petitioner was posted on the post of junior engineer in the year 1960 and superannuated from service on 31/1/1986. The dispute is regarding the post retrial dues. A show cause notice was given to the petitioner on 6/7/1997 and he was explained as to why the amount be not recovered from him because shortage of material. It is contended that the provisions of Rule 351A of Civil Services Regulation have not been followed. The petitioner repeatedly submitted that he could not produce the documents by which the recovery is being directed as he retired from service on the prior date. The order of the recovery dated 19/3/1988 therefore is per se illegal. The basis of the petitioner's contention is that there is specific provision under Rule 351A of Civil Services Regulation that no proceedings can be initiated after the superannuation without seeking prior permission of His Excellency the Governor, and that to regarding the incident which happened 4 years earlier, the retirement. In the instant matter, the recovery relates to period which is beyond the 4 years. Therefore, in any circumstances, the recovery is altogether baseless, void, and illegal. The payment of pension or gratuity of government servant cannot be withheld merely on account of any inquiry pending against him. The government has issued execution direction in the matter of grant of pension and gratuity to the retired government servant contained in GO dated 3/9/1982, which provide no departmental or judicial proceedings or any inquiry or administrative tribunal has been instituted against the government servant. He shall be paid full pension gratuity admissible under rules. Till his retirement, no inquiry was instituted against him. Despite making several representations dated 2/9/1986 and 5/4/1988, his pension was not released. The action of the opposite parties are arbitrary without rules. The opposite party number 3 issued show cause notice only on 6/7/1987, requiring him to furnish his explanation towards shortage of stock and T&P detected against him. The petitioner submitted that through reply that these items has never been received by him. The petitioner was not shown relevant papers, and the opposite party number 3 did not go through his proper replies and passed an arbitrary order for recovery of rupees 267,667.84 and withheld his post-retirement dues. The petitioner preferred a claim petition before the UP State Public Services Tribunal, but the tribunal was of the opinion that the petitioner retired on 31/1/1986 and show cause notice was issued to him on 6/7/1986. It is submitted by the opposite parties that the shortage of stock and T&P came into the light in the year 1981, and immediately thereafter the show cause was given to explain the shortages. The tribunal was not satisfied with the explanation given by the petitioner that the inquiry was instituted after the retirement and related the matter with effect from 1981. Source 3P Legal, rhc, exercise number is 30, and words are 807.